Is Matteo Terbarelli. Good afternoon, everybody. My name is Matteo Terbarelli, and I am the president of the Sports Communications and Entertainment Law Forum here at Notre Dame. The goal of the goal of SCELF here at Notre Dame is to get law students interested in a legal career in sports, explain to them possible opportunities in which they can get involved, ways outside of the JD preferred methods of getting involved in sports, be it being a sports agent, getting involved in big law on the sports aspect of the legal profession, and any and all opportunities that they can get involved in sports. So thank you all for coming, and we are excited to host the panel here. And I'd also like to introduce Alexa Shikarnik, the Vice President of the Business Law Forum here at the law school, who is also co-hosting this event.
Great. Thank you, Matteo and Alexa, for all of your work and assistance in getting the word out about this event. So this event is talking about, it's very rare that you have a legal issue that is truly a change in the paradigm about the way a particular market is going to be addressed. But today we're going to talk about a paradigm shift that has happened in 2021 with respect to the issue of student athlete compensation and what the future looks like and what the past has been like. And so today's discussion is going to be about the emerging norms, the emerging rules with respect to name, image, and likeness compensation, as well as changes to the educational benefits rules with respect to the NCAA as a result of the Alston v. NCAA decision. So I'm going to be moderating. My name is Roger Alfred. I'm a professor of law here at Notre Dame, but as much as possible, I'm going to try to stay out of the way for our panelists and let them talk about the whole range of different issues that are coming up with respect to student athlete compensation. So just to set the table, let me read you a quote from Justice Kavanaugh this past June in the Alston versus NCAA decision that the U.S. Supreme Court rendered in June of 2021. And I think when everyone in the legal community read this concurring opinion, you think, wow, like this is really remarkable. So here's what Justice Kavanaugh said in the Alston case. The NCAA's business model would be flatly illegal in almost any other industry in America. The bottom line is that the NCAA and its member colleges are suppressing the pay of student athletes who collectively generate billions of dollars in revenues from colleges every year. Those enormous sums of money flow to seemingly everyone except the student athletes. College presidents, athletic directors, coaches, conference commissioners, and NCAA executives take in 6- and 7-figure salaries. Colleges build lavish new facilities, but the student athletes who generate the revenues, many whom are African American and from lower income backgrounds, end up with little or nothing. The NCAA's business model of using unpaid student athletes to generate billions of dollars in revenue for the college raises serious questions under the antitrust laws. So speaking frankly, as someone who is a student of antitrust, it's always struck me as odd that Alabama head coach Nick Saban has an 8-year contract that exceeds $84 million, while the dozens of athletes who play for Alabama receive no compensation whatsoever, except, of course, scholarships to attend school at Alabama. The players on the field playing the game receive scholarships to attend Alabama, but Nick Saban, standing on the sidelines, receives over $10 million a year. If you divided Nick Saban's salary of $10 million a year equally among the 22 starters of Alabama's offensive and defense, each player at Alabama would receive $450,000 a year, just slightly more, shall we say, than the $12,000 they receive in in-state tuition every year, or the $32,000 they receive in out-of-state tuition. Or, alternatively, if you cut Nick Saban's salary in half, each starter on the offensive and defensive of Alabama would get $225,000 per year. And you sort of got to wonder whether Devontae Smith, who won the Heisman Trophy last year and now earns $5 million a year for the Philadelphia Eagles, thinks it is fair that Coach Nick Saban receives $10 million in compensation each year, while he was played at Alabama, received nothing except a scholarship. Or, to put it even more starkly, you got to wonder whether the Alabama players who never will make it to the pros think it is fair that Nick Saban receives $10 million a year while they receive a scholarship to earn a degree from the University of Alabama. We are in the midst of a changing landscape. We're a long, long way from direct compensation to student athletes. But recent developments suggest that the landscape for student athlete compensation is in flux. Today, we're going to talk about Alston versus NCAA and the new rules with respect to name, image, and likeness. These rules suggest that the education benefits that schools can provide to student athletes are broader than the existing status quo for NCAA, but the exact contours of those increased educational benefits are still yet to be determined. Likewise, after 25 states imposed state laws requiring the NCAA to provide name, image, and likeness compensation for student athletes, we now have an emerging new market in which student athletes can receive compensation for their name, image, and likeness. So that is what we're going to talk about today. And we have a wonderful panel. I'll introduce each of them separately at the beginning of each of their presentations. Sonny Vaccaro is a legendary sports agent in American sports. He is perhaps best known for brokering major endorsement deals with basketball stars like Michael Jordan and Kobe Bryant. For years, Sonny has been an outspoken critic of the NCAA and was one of the earliest to argue that student athletes should be compensated. It is not a stretch to say that the connection that we all associate between Nike and the basketball world would not be possible without Sonny Vaccaro. His work with Ed O'Bannon promoting the rights of student athletes laid the groundwork for the emerging rules regarding compensation for name, image, and likeness. And Sonny, we look forward very much to you providing a bit of history on the efforts to alter the current landscape with respect to name, image, and likeness. So Sonny, you start. Thank you.
Thank you. To everyone watching, thank you, Notre Dame, for having me, Roger, for putting this together with Makan and the other people. I want to start off by saying this is not going to be anything to do with name, image, and likeness and all the other things. What it's going to be to do is the athlete itself and how we got ourselves into this mess 120 years ago. I haven't lived for 120 years, so I can't speak of that the first time. But what I can speak of today is from my heart and my mind and no actual involvement. I'm referred to as a lot of things. In fact, everybody watching this and the fellow panelists, I'd like you to think without raising your hand, since I've spoken at a lot of universities these last, since 2007, since I left corporate, I've been on the road speaking to universities, and not once did I ever speak to a basketball or a football team or any other all team. I spoke to journalist schools, I spoke to business schools, I talked to law schools, and never did anyone from the athletic department show up other than Yale. And I happen to know Tom Beckett from a long, long time ago when he was the AD at Yale. I want to make that clear. I want to make my crusade started a long, long time ago. And the first time I ever heard of name, image, and likeness, not in that phrase, was from a young athlete named Dick DiVinzio, who played basketball at Duke, and who was a high school player in Pennsylvania. And Dickie DiVinzio played for me. His father coached my first event I ever did. It was a round ball classic. Now I want to get to it, but I want to pay homage to Dickie, because Dickie thought of that when he was a 21-year-old, ex-student, ex-athlete at Duke. And he died a tragic death, in the last years. But he went through a life of believing that the athlete was getting wronged before anyone did, including Sonny Vaccaro. I want to tell you what I think is wrong. I think the whole system's wrong. And I think what's happened up until today, until this wonderful forum that you're having here, because what has taken everyone so long to understand what we're fighting? We're fighting with the greatest discrimination in the history of mankind. I know I over-exaggerate, and some of my media friends will say I use that. Well, every time I say that, I mean that to the fact that I'm talking about something. I say that I know where the problem started in England. And who better else would be discriminatory towards the lower class than the English? Who better? Who better would have said you go in one gate and the other one go in the other gate than the English? Who better would have thought tennis was the ultimate sport, or golf would have been the ultimate sport? They didn't even know football and basketball. But what happened was it gave an opening to a group of people years later, because I can't really refer to the NCAA until 1951, when the real open-hearted illegitimacy happened. But the early days were, I can go back to Pittsburgh and remember a lot of things. Now, I wasn't born in 1920, although I may look at it. But in 1920, the greatest scandal that ever hit sports was the scandal of football. When I knew for a fact 50 years later, and I read all the things that happened, especially at Pitt, that most of the guys worked where my daddy worked, in the steel mill, in the coal mines, or in the railroads, and they'd be substitute players. They would never go to school. We know that for a fact. And the greatest thing that ever happened was all the good schools, because mostly it was Ivy League dominated. There's no question about that. But the University of Chicago, they had that name is living forever not because they're one of the great universities, not because they discovered how to split the atom bomb and all the other things, because they walked away from playing football because it was too damn dangerous. Isn't that interesting? Now let's go to where Sonny Vaccaro comes in. Well, man, I first started knowing, of sports because I love sports. And if you lived in West Pennsylvania in the 50s and 60s and 70s, that was your other origin. You had a sport-related identity with life because of all the small communities. And I remember the happenings, and it was later in my high school and early college career maybe that I remember vividly. And I only remember this because of things in the future that were about to happen. But the NCAA, although illy run, was a bastard child then. You remember the great scandal at the great University of Kentucky when everybody was cheating and throwing games and all the things that made headlines in the future. We had kids throwing games in the 1950s under the great Adolph Rupp, and the great, if anybody was an icon before other icons were made, it was the Kentucky basketball team, okay? I'm not picking on whatever happened or didn't happen then, I'm telling you a fact. It took this long. And then we had Mr. Byers took over the NCAA. And as we progressed through the NCAA, I was able to witness close hand. I'm probably the only person living that's intimately involved with still what happens today. I go from Byers to the guy running it now. I say the guy running it now, obviously I know his name, but that's all I can refer him to because I don't know who the hell or what the hell he's doing. But I'll get off of that. I don't want to be mean. I don't want to be discriminatory. I want to tell you all a little facts here. What are we watching? Why are we this way? We allowed it. Every one of you, me, everybody. And who allowed it? All the universities. The great universities of America allowed this ugly, ugly scene to happen. They only cared about one thing, was the revenue. And it started growing and growing and growing until in the 50s and then the 60s start growing. Then the NCAA became really enamored. Now I start really paying attention. I didn't give a damn about the NCAA. Now you all know I started a high school game when I was 24 years old, an all-star game, but it turned out to be successful. I had not worked for Nike now until 1977. So you people forget that damn stuff, okay? It's immaterial to our conversation, okay? But in the 60s, I watched the transition of America. This Italian kid from Trafford who really didn't understand what was happening, even with Dr. King, okay? I knew there were problems, but I didn't understand. It's not like today. It's not like we know everybody when they sneeze and go to the bathroom. We didn't. I knew there was a problem, but I also knew there was a problem in athletics. The first time I knew their problem was John Carlos and Tommy Smith at the Olympic Games, and they put a black glove on. Then I watched progression inside the NCAA. Then I watched football players on the West Coast starting to rebel against certain things that were happening to blacks specifically. Now we had 4-year scholarship because Sonny Vaccaro is here today. I never played a down of football in my life at the school I ended up with at Youngstown State. They kept me on 4-year scholarship because I got involved in basketball. Ladies and gentlemen, I had nothing to do with basketball until they told me. I was a football player at that time. My point to you is that started making me think. Then they changed the rules, not so much to change the rules, but I really believe to control the athletes. Because out of nowhere, we're now giving them 1-year scholarships and at our discretion. So let's continue. Let's continue on this morbid climb through greed and self-preservation of their own. In 1972, they finally recognized that women were playing sports. They thought of something. It wasn't Title IX yet. It might have been Title 2085. But I think it was that Catholic school in Philadelphia. I forget the darn name. But I think that nothing really was concerned about women. It was, I don't want to use the word abusive because that really name is there. It was some sort of something that they finally thought that let's consider girls' sports. Now, it took until last basketball season really to understand that girls' sports is really important. Because if that lady don't go down to the locker room and say that that locker room's crummy and bad and prepared, I don't know what the hell happens. And I don't know why, because ever from Title IX, I've been watching all the legal things now for like 30, 40 years. Not as intimately I was with him, but I can say for the Michael Hospital, the Bill Isaacsons, the Jeff Kesslers, the Ramogi Huma introduced me to himself in the 70s. The guy Johnson, the Oliver case. All these lawyers, all these athletes started the band together. We started getting lawyers defending them. But it still took time because we lost the Region case, although we won the Region case. But Wizard White wanted to say something on the way out to say goodbye to the guy. Hey, by the way, screw these athletes. And that was dogma then. We just continued everything from them. Why am I saying all this? Because we allowed it to happen. You guys allowed it to happen. The universities allowed it to happen. Why did Notre Dame allow it to happen? This great university at Notre Dame, Yale and Harvard and everybody else, and all the little ones, all the HBCUs. Oh my God, isn't that interesting? I said black colleges. Black colleges have been around long as white colleges. It's interesting to me that in the early days, when I was a kid growing up in Pennsylvania, I remember Grambling. I remember the basketball players that went to these schools because they couldn't get in white schools until Sam Cunningham jumped over the line and beat the hell out of Bear Bryant down there in Alabama. They didn't even realize black guys were playing. Nothing was ever equal in college sports, people. What are we arguing about? Mr. Kavanaugh, I don't agree with you 99% of the time, but that day there, you made my heart to heaven. The 9 members, all 9 of you, because it was 9-0. But what I'm saying to you, look what I just told you in 5 minutes. 5 minutes, they allowed everything. Now we got this guy, Byers, right? Now what are we doing? We're starting to buy our properties. We're starting to buy, they bought the NIT, they own the NCAA, but they never controlled football because even when they walked out and there was a white thing there, they kept playing. They kept insisting for 20 some years that they were immune because he said something. They were always in violation of antitrust from day one. They were from day one, not on that, just the Regions case, on every case. But what's more egregious than them disagreeing is how they treated the athletes, and how the money start coming off from the top. I just want to understand something here. In the recent years, because I'll reflect back. In the recent years, I don't know how we get millions of dollars, in bonuses to commissioners. I have no idea. They did a job. They did a television contract. We're going to give them a bonus. I don't know what that means. The bonus should be that the team was coming on and playing the next. That's the bonus. Now, Roger, I don't directly agree with. They can give whatever this guy's name, the coach at Alabama, $100 million if they want. But they better figure out how the hell to get the other 100 there because they have it. They have it. Maybe it should be all correlated in some way. But I wouldn't give 22 players. I'd give all 90 players in football and all 20 players in basketball and all 25 in baseball. You're going to give all the guys. Only if it's what? If it's a group thing, like O'Bannon was, okay? If it's a group thing, then they all got to play. If the team's playing, let me tell you what I suggested a long time ago, ladies and gentlemen, after following all this, I'm leaving a trail behind me now, right? But here's when I first decided this stuff, my wife came to me. She was a commercial actress at one time. And in the 90s, she said out of place, you may have heard this story, it's the truth. Sonny, do the kids get residuals? I was watching Classic Sports, who friends of mine, Brian Bodell and Steve Greenberg, sold for $117 million for the rights of the films that these kids were playing in. That's the first time I was ever aware of what was happening. I was watching them, never enter. I was looking at the other things they did to athletes at that time, the recruitings and everything else. I don't want to go up, but that's how it was. So I looked and no, they didn't get in, but they sold it. So schools got all the money. And that's what started the NIL thing. The biggest mystery in the world to me is how all these years they struck in under the contract of the scholarship the name, image, and likeness thing. It was just something they signed, 10,000 things. You tell me, all you people who follow sports, maybe your brother, maybe your aunt, maybe your family's probably a fan of somebody. And somewhere along the way, before 1996, those kids were signed. What was the greatest thing in your family when you got that scholarship? When you got that scholarship and you're going to school and they're telling you you can come, you earned it. That was a pride thing. You weren't looking at goddamn name, image, and likeness. How the hell could they think of that? Because of all the egregious things they did, I said this before and I'll say it till I die. All the gall, all the things they've done, and we allowed them to continue to fight back at us. But we don't, nobody owns my name, my image, except my parents and God. Nobody. That reached for the stars. They just put it in there. And there wasn't a kid in the world that wasn't going to sign it, because why? We hadn't even started thinking of giving them money. You know, Roger, you said something, the price of the scholarship. You know what I asked? I asked this to Housfield, the first thing, and it never went beyond it. Never went beyond any of the other time. What if I paid for my scholarship, Roger? What if I didn't take their money? Could I then have name, image, and likeness? They're not giving me anything then. Why can't I just pay it? I'm not taking any money from the school. You can give the scholarship to another athlete. I'm not depriving an athlete of a scholarship. And if I'm good enough, play me, sir. Well, if I'm doing that, I must think I'm pretty good. And if I'm doing that, my value, as we're watching on television now with the football, these idiots in nine minutes like this, some of these sponsors, they made a big mistake where at Oklahoma or Texas or something where the wrong quarterbacks to start out. But you know what? That kid's okay in me, and he'll probably be a good pro. What I'm saying to you is we opened a floodgate. I think what Ms. Skinner did, I think I'm trying to get it, caught up for you guys. I think the name, image, likeness coming from the States was a great thing. I remember when Ramogi asked me to be part of it. I couldn't be part of that because I'll die being part of Hostile, just like I know Jeff Kessler, vicariously over the years. And Jeff and I talked a few times. I know the other guys, Hagen Bermans. I know all these lawyers. But the point is, when you're on to something, when you're with somebody, you're in. So this name, image, and likeness thing has gotten to a point now where, what are we doing? Well, before I come back to the States, I want to go into one thing that upsets the hell out of me. I get calls from everybody. I talked to Pete Mills from Senator Murphy. I talked to all these guys, all fine room. I talked to the Democratic or the Republican leader. He was really, really nice to me in Florida. They asked me, I ask questions and I love it. It makes me feel good because I don't look at Democrats and Republicans. I don't look at Catholics and partisans. I don't look at atheists or anyone else. I look at you as a human being. And so the fight was consistent no matter what side you were on. It was about the athlete. That's what it was. So you know what the biggest problem we have now? We're like this, the Democrats and Republicans, okay? We're going to defeat what we're trying to stop. We're going to defeat ourselves. You always do it. Somebody wants, I watched that thing, this senator wants this, and this senator wants that. They want to do this. They all want to do something. Do it together. On name, image, and likeness, on student athletes. Get together. Quit the bull crap. Don't allow it to happen. We're going to kill ourselves. Go ahead, Roger, you're ready to say something? Go ahead. I know I just keep talking.
Thank you very much. I think you're winding us up. Thank you, Sonny. Okay, our next speaker is, I'm very happy to introduce Makan Delrahim. I had the pleasure to work with Makan Delrahim while he served as the Assistant Attorney General for Antitrust Division of the Department of Justice from 2017 to 2021. I worked directly with Makan on a daily basis. I fondly remember those 9 a.m. meetings. I was happier when you moved them to 9 a.m. from 8 a.m., but I fondly remember those 9 a.m. meetings every single day. For the 2 years that I was at the DOJ, I served as a Deputy Assistant Attorney General with you and worked very closely with you during that time. And Makan, you've had a significant interest and role in promoting more vigorous antitrust enforcement with respect to the sports industries. As Assistant Attorney General, Makan Delrahim came to Notre Dame in August of 2018. His first speech as AAG with respect to the sports industry, and you spoke in favor of federal court decisions such as the Ninth Circuit's decision in O'Bannon versus the NCAA. in that speech, I think it was in this room in August of 2018, you said the following: the sports industry is a profitable one whose goals and unique attributes are complemented by sound antitrust policy. With limited exception, leagues, governing bodies, or teams can and should have their conduct tested against the crucible of the antitrust laws. Then in October of 2020, you came again to Notre Dame, Makan, and you spoke again about the sports industry. And in that context, you said that the NCAA rules that were emerging with respect to NIL will, quote, completely change the landscape. And that, of course, since October 2020 is precisely what has happened. So, Makan, thank you so much, and we look forward to your comments.
Roger, thank you so much. Thanks for inviting me back to Notre Dame. Of course, as a former Bruin, I would always be rooting for whoever's playing the USC Trojans. But over these last 3-4 years, me and my family, we have adopted Notre Dame as the team we would root for. And it's become, thanks to the invitations to be there and really discuss one of my favorite topics, which is sports and antitrust. We have grown a fondness, and I'm just regret not being able to be there in person. But I will be rooting for the Irish tomorrow in that game. And it's a great honor to be on this panel amongst some of the great legends, some known, some unknown until now. But Sonny's reputation and I think the ESPN feature, I believe it's a 30 on 30 about him and his career and his impact on sports is legendary. So it's a true privilege for me to be on this panel. And of course, Jeanifer was part of that leading team with Jeffrey Kessler that litigated the Alston case and is largely responsible for the situation we're in now, with really opening up and this incredible decision at the Supreme Court. And of course, Lori is now implementing a lot of that and guiding both the athletes and maybe some of the schools on how to go about it. Now, there's a lot here. What I love is the fact that sports and antitrust live these great parallel lives. I mean, what would sports be without competition? What would sports be without rules to keep the competition fair? And essentially, that's what the antitrust laws do. They ensure that, in the marketplace, you are fair. You have a fighting chance that somebody does not use the system, whether collectively or individually, to make the playing field unfair for one side or the other. If you haven't, for some of the students who may be watching, if you have not read Justice Gorsuch's decision and Justice Kavanaugh's, but Justice Gorsuch's holding in the Alston case, as is characteristic of his writing style, it's incredible. It's easy to read. It's not, legalistic gibberish that sometimes Supreme Court opinions or just judicial opinions might be. He always has this incredible writing style that makes it fun. And this one goes back, and he starts with the 1852. It's about 40 years before the antitrust laws were even, written in the United States with the Sherman Act in 1890, and about 30 years before the first antitrust laws were ever written anywhere in the world. But 1852, of course, is the Harvard versus Yale competition, and where money flooded into that really interesting competition because some railroads wanted to promote a resort, and they paid for a 2-week vacation to the athletes who were competing to come there, and they promoted the heck out of it. So we've had money in sports and collegiate sports since going back to at least 1852 and over time. And in the opinion, he recites this history, and I should probably put a plug in here for one of my colleagues at the University of Pennsylvania, Dr. Karen Weaver, who teaches in the Department of Education and really provides this program for university presidents and athletic directors. But her book just came out, and it's called Sports Finance. And it goes more broadly than just collegiate sports, but there's a chapter specifically about sports, which is a wonderful resource. But in the opinion, they recite through the whole history of when did the NCAA, why did it come in? How did it come about? And of course, President Roosevelt, and it really started as a standard setting organization. And of course, the antitrust laws have a lot of experience recently with standard setting organizations outside of sports, but it really came in to try to provide some safety standards initially. And then it evolved into what it was. They had some rules where they say no athlete could be compensated. And then there was, cheating that sometimes occurs when people transgress the rules in order to win in competition. And then the rules continued until, around the 1940s when the NCAA kind of came in with, I believe they called it the sanity code, for which they now created the ability for scholarships and then the punishment for expulsion and ineligibility. And then, we've had a number of, and throughout those years, the antitrust laws have been used to challenge different rules. The Ed O'Bannon case was a groundbreaking case, but it was not the first. It is the Supreme Court had a ruling in the NCAA versus the Board of Regents in 1984, a decision for which the NCAA hung its hat on a handful of words in that case to try to claim that they're immune from the antitrust laws, that because of amateurism, they deserve a certain deferential treatment. And I wish there was a representative from the NCAA on this panel. An invitation certainly was sent to them, and they decided not to appear. But it would have been good to hear from them about some of their justifications. They advanced this, of course, in the Supreme Court, and one by one, whether it was the quick look or whether they deserved a certain deference or no application of antitrust law because this is, these are, nonprofits, universities, and these are rules amongst them, or it's a joint venture. Justice Gorsuch, in a unanimous court, just went by and said, no, they do not apply. And you cannot limit the compensation for academic-related compensation. Now, athletic-related compensation is, remains to be limited. That wasn't part of the holding. Whether or not that gets challenged, Justice Kavanaugh seemed to invite that a bit. It'll be interesting. But the Supreme Court gave a lot of leeway to the NCAA and to the district court in a consent decree about what exactly the rules will be. It basically said, no, you're not immune from the antitrust laws, but there are some limits that could survive. And it's really up to you to challenge, if there's a specific rule. I've heard the NCAA say, well, because of this, we can't do anything. We can't have rules, blah, blah, blah. And therefore, we must get statutory immunity from the antitrust laws. But that's not, I think, a fair reading of the opinion. The specific, explicit provisions from Justice Gorsuch's opinion says, no, there are some restraints you can put as part of this enterprise to protect students and protect amateurism. It's got to be consistent with the antitrust laws, but there is. So I think it'll be interesting to see what that means. Now, what does this mean? What does this mean? Because you have a number of states. I think, Roger, the last time we were there, we did the Q&A with you, the state of California was either about to or had just enacted its rule to require name, image, and likeness compensation. It delayed it, I believe, till 2023, its enactment. But what that created was competition amongst the states. Alabama, Florida, they started now introducing new legislation. And look, the NCAA has done an incredible thing, I think, for democracy in the country. I don't think legislators in Sacramento, Republican and Democrats, could agree on the time of the day or the color of the sky but unanimously they passed this, and Governor Newsom signed that legislation. And they also were the cause of the Supreme Court, and even a divided Supreme Court at times, to unanimously agree that the antitrust laws should apply to the NCAA. So we do have them to thank for some of the bipartisanship that they have created in this area. But you now had competition, and the state rules went in, and I think the NCAA was probably rolling the dice a bit, waiting to see if the Supreme Court was going to grant it some kind of a blanket immunity from the antitrust laws before it put in new rules. And of course, they don't. So we will, I think, have to wait and see to have the type of guidance that universities like Notre Dame or practitioners like Lori, who represent brands and student athletes and others through their various businesses, of exactly what are the contours, who can pay for what are the limits, are there any limits, can schools impose rules? And of course, under the antitrust laws, individual schools could. This ruling applied to the collective rulemaking or standard setting by the NCAA. So there's a lot of questions that still remain, but there was one question that I don't think anybody has, is the continued viability of collegiate sports and the continued presence of money in there. What's great is that the students will now be able to be properly and fairly compensated, consistent with the antitrust laws, and perhaps depending on some rulings within the labor environment, some labor laws that might apply now as well. With that, I'm looking forward to the discussions in the Q&A.
Thank you very much, Makan. So unfortunately, Jeff Kessler had a last-minute cancellation and he was unable to make it. But luckily, you can just basically go to the Winston Strawn Rolodex and find a half dozen other experts immediately to fill in for Jeff Kessler. So I'm very, very happy, Jeanifer, for you to be able to a partner at Winston Strawn with Jeff to talk about the issues related to student athlete compensation and the Alston v. NCAA case. So it's almost no doubt that Winston Strawn is one of the leading law firms in the world representing athletes challenging anti-competitive conduct with respect to amateur and professional sports. If you want to be a sports lawyer, you got to think about a place like Winston and Strawn. Jeanifer Parsigian is a partner at Winston Strawn in the San Francisco office and works in their sports and antitrust practices. As an accomplished litigator, Jeanifer regularly represents athletes in high-profile matters, such as the Alston v. NCAA case, which, of course, as we said, the Supreme Court upheld 9-0. She also represents the women's national soccer team in their gender discrimination lawsuit. She's currently counsel for a class action of Division I student athletes in the House versus NCAA antitrust litigation, which is seeking past damages and injunctive relief to the NCAA's rules prohibiting student athletes from benefiting from their name, image, and likeness. Jeanifer Parsigian is also, you'll be happy to hear, a distant cousin of the legendary Notre Dame football coach, Jeanifer Parsigian. So, Jeanifer, we look forward to your comments.
Thank you so much, Roger. I think you buried the lead. Everyone here was wondering how related I am to Era, who is a fabulous football coach, but is only a distant relative. So first, I'll convey Jeffrey's apologies for not being here. He was really looking forward to it and being on this illustrious panel. But I was thrilled to fill in. I'm honored to be here with this group of legends, and it was great to hear from Sonny and Makan, and I look forward to hearing from Lori. I'll also admit that I'm still thrilled to hear folks talk about Alston. The excitement of it hasn't worn off. We had litigated this for a long time. And winning 9-0 in the Supreme Court was huge. We're so happy to see the changes that have really started taking place, and so it makes me still so proud to hear others talk about it and the impact that it has. So I am a huge sports fan. I'm a huge athlete fan. Roger shared a little bit that we have, you know, a significant sports practice, and it's really focused on athletes. We work with the major leagues players associations, and I have been litigating on behalf of athletes, college athletes, and the women's national team quite a bit in recent days. So it's really, I echo what everyone says about the unfairness to them, and I think, you know, there is really inspiring to be able to work on their behalf. I'm really impressed constantly with what they have to do, and their commitment, and their resilience, and their work. But having said all that, I am going to come at you all with a little bit of a different perspective, and that is of an antitrust dork, because that is what I am. And you know, Makan talked a little bit about this, and Sonny talked a little bit about this, of how this, you know, is really a stunning antitrust violation. The Sherman Act Section 1 prevents unreasonable restraints of trade, and what it primarily prevents is agreements among competitors, and especially agreements among competitors to fix the price, which is what the NCAA has done. Is they've fixed the price of labor at the value of a scholarship. They've done it for years and years, and they have used, as Makan said, a handful of words in a Supreme Court decision that's about 35 years old to insulate themselves from antitrust scrutiny. And I think something I want to touch on is that has worked. There have been a lot of challenges over the years to NCAA rules relating to amateurism, and courts have often been convinced by the idea that the Supreme Court's Board of Regents decision kind of insulated them and blessed the rules. And maybe they also just didn't want to go there because it seemed like it would disrupt this big industry, and courts were hesitant to do that. So as an antitrust lawyer, it's really amazing that worked, because what they have is usually per se illegal. I mean, they have an agreement that's out in the open. It's written down in a hundreds of pages rule book, and it's all the competitors for student athlete labor that there are have this agreement. So the fact that it's been allowed to exist for this long is really against, in my mind, the entire purpose of the Sherman Act, and it's really a unique situation. So we came to this case bringing it, you know, somewhat into the O'Bannon litigation, which focused on name, image, and likeness rights. And our case, the Alston litigation, was focused on both student athlete compensation, both education related and not education related. And we said, you know, these rules just shouldn't be able to stand. And in our, you know, argument, what we've said is that the deference that the NCAA gets is that it gets a rule of reason analysis, which is not the per se rule that it's automatically illegal, but it is something where a court will consider justifications that the NCAA offers to justify the anti-competitive effect of their rule. So that's how our case proceeded. And it proceeded over the years. We had the change to allowing cost of attendance scholarships. And we developed in our case a lot of evidence about all the ways in which schools did pay student athletes outside of scholarships, that there were these kind of slush funds that they would have to give iPads and other sorts of benefits. And the significance of that wasn't that we thought there was anything wrong with it, but the NCAA had maintained all the ways in its Board of Regents that you couldn't get a penny more than the cost of attendance to student athletes, or consumers would lose interest. I mean, I think Makan talked about the continued viability of the sport. I think everyone is sure that despite the change in NIL rules, despite our win and the increase in education-related benefits to student athletes, that college sports remain a viable business. But, you know, believe it or not, that is the primary way that NCAA defended their conduct. They said, you know, we have to have these rules or people would not be interested in sports. One of my favorite moments from the trial that we had was Rebecca Blank, who is the chancellor of the University of Wisconsin. She's an economist. She is a brilliant woman, but she came, she came to testify for the NCAA, and she talked about how it would impact Wisconsin if we won our lawsuit and if, you know, they were allowed to pay the student athletes. And she said, you know, I don't know if Wisconsin would continue. We're in the business of student athletes. We're not in the business of professional sports. Well, our trial was relatively well publicized. That statement got out in the media, and by the time she had landed in Wisconsin, they had already essentially issued a retraction of her statement and said, no, of course, Wisconsin is going to be involved in sports. We will work with the Big Ten. We will have whatever rules, and we will move forward. Because there was such an outcry from donors and alumni and students that there could possibly not be football. So that is kind of a microcosm of how I think that justification has started to play, and has, you know, the public has come around to seeing that really can't be true, that this billion-dollar industry, billions and billions of dollar industries cannot be, you know, destroyed merely by this change in the rule. So we won our trial. We were obtained an injunction from Judge Wilkin in the Northern District of California. She said that the NCAA could not limit education-related benefits up to the amount that they allow benefits for athletic participation. And what is meant by that is the evidence showed that there are a lot of benefits that the athletes get, including, you know, cash payments related to awards like MVPs and bowl games. And it added up to, you know, about $7,000 a year that they could get. And she said, you have to allow cash education related benefits up to that, and then various other things like computers and other things that would support them in their education. Because one thing that I think the NCAA did do relatively effectively at our trial was explain that the fact that these kids were students was important, and that, you know, serving that goal did matter in some way. So we said, well, if that's the case, then you can't possibly justify limiting these education benefits. So the fact findings were the primary driver of the decision there. We went up then, the NCAA and the conferences appealed to the Ninth Circuit. We were affirmed, and then to the Supreme Court where we were affirmed. And I think we've talked a little bit about Justice Kavanaugh's decision. There was also a concurring decision in the Ninth Circuit. Both of those decisions were by some of the most conservative members of those courts, which I think shows that this is not a Republican Democrat issue. Antitrust in particular is about free markets. I mean, this is absolutely about free markets. That is a conservative value in many, many ways. And so the concurrence in both cases said, essentially, you know, this didn't necessarily go far enough, that it's unclear that this justification that they have of, you know, preserving interest in sports, the consumer's demand for it, can really justify any of these restrictions at all on student athlete compensation. And going back to the trial, the NCAA's, you know, a major witness from them, Kevin Lennon, couldn't testify to any instance that they had ever considered consumer demand and the impact of consumer demand on college sports and having these rules. He testified that they considered cost. And that's a classic cartel justification, is that they're trying to contain the costs. So that it was kind of the outcome of our case, and we were very much encouraged by Justice Kavanaugh's decision that antitrust scrutiny for the NCAA would be alive and well. So now we have the House litigation. In the meantime, shortly after the Alston decision, the NCAA changed its rules on names, images, and likenesses. I think, you know, in my mind, names, images, and likenesses are an easy place for the NCAA and the schools to start, because what you have there are third parties that are going to pay this money to the student athletes. So it helps continue to insulate them from the financial change that it would mean for them if they had to pay market rates for the student athletes. But at the same time, it helps them kind of counter the arguments about unfairness that they have been more and more subject to. So the NIL rules have changed. We now have a litigation called House v. NCAA, where we are seeking past damages on behalf of student athletes for all the NIL deals that they could have done over the last 5 years, the statute of limitations for the antitrust laws. It remains a little unclear what the NCAA will potentially argue justifies the rule or justified it over the last 5 years, now that they've made an interim change to it. And we're also looking for damages for the broadcast rights because and group licensing, because things like the EA video game, which stopped existing after Ed O'Bannon's lawsuit because they use the names, images, and likenesses without any compensation. And every time your athletes are on TV, and Notre Dame has a very lucrative deal with NBC for its football games. Other conferences do as well. I mean, there is really so much money in this, and none of that money is going to the athletes. So we're challenging that. And it's a group licensing issue for their NIL rights. And it remains to be seen what the NCAA will put together as what they think justifies those rules now that we're in a world where the name, image, and likeness deals you're hearing about new ones every day, and it's benefiting the athletes. And as we've seen, there has been no negative impact on demand for college sports.
Great. Thank you very much, Jeanifer. Well, in light of these changes, we know that everyone in the sports, the NCAA sports world is trying to figure out where do we go next. I have friends in the general counsel's office at Notre Dame, and I know they're working really hard to try to figure out what the rules are, what the emerging norms are going to be, what they can advise administrators as well as athletes. I know that every college with potential name, image, and likeness compensation for their athletes is trying to struggle through with this issue. I did also, in addition to inviting the NCAA representatives, invite the Notre Dame General Counsel's office to come and speak as well, because I didn't want to have just the athletic perspective on this panel, but unfortunately they were unavailable. But what we do have is someone who is an expert in the world of sports agencies. Lori Odierno is one of the nation's leading experts, leading executives in the sports industry, the sports agency industry. She is the head of legal and business affairs at William Morris Endeavor Sports, or WME Sports, where she oversees all legal matters for the agency's representation of active and retired athletes, broadcasters, coaches, and front office personnel and sports properties, which is quite a responsibility, I have to say, Lori. That's quite impressive. WME Sports is part of a leading talent agency, William Morris Endeavor, and for the last several years, Lori has devoted substantial time and effort to understanding and complying with the NIL laws and policies applicable to WME agents and clients. So Lori, you're gonna, in light of the changing landscape, you're actually trying to implement the landscape with respect to the agents and the athletes that you guys represent. So thank you, Lori, very much.
Nice to hear.
Yeah, sure.
Fantastic. Thank you, Roger. Thank you, Megan. Thank you, Jeanifer. Sonny, it's fantastic to hear you, talk to us all and share, all of the observations that you've been making over the years, and it must be really exciting for you to see finally some change in this area. I am not an antitrust lawyer. I wasn't even, I didn't have anything to do with the NCAA until several months ago, frankly. As a lawyer for a sports agency where we represent professional athletes, retired athletes, I started watching this issue pretty closely when the California legislation was enacted. To me, that was a bit of a California Governor Newsom poking the bear. They passed a bill that really didn't have a tremendous amount of substance to it. There are not a lot of rules about what college student athletes can or can't do. It was very kind of, if you don't figure this out by 2023, this will happen. It was a little bit of a call on an option price or something. And the NCAA sort of pushed back, and they didn't want to deal with it. And other states that I think started to look at this as an opportunity to get in and have a recruiting advantage around other athletes said, well, wait a minute, we're going to make a law like this, and we're going to make it effective in 2021. Why not? Let's do it. So it was sort of game on at that point. So you started seeing some bills, and then there were folks in between where, well, maybe we'll make ours effective in 2022 because folks wanted to wait and see what the NCAA did, if anything. And what they did was threaten to, keep the California schools out of bowl games and, did their usual huffing and puffing. And then Jeanifer and Jeffrey and the Winston crew argued very persuasively in front of the Supreme Court in the Alston case. And that was just a complete game changer. I still will admit, I don't fully understand exactly what the holding was in the Alston case. I know it was very narrow. I know it has nothing to do with the deals that, the agents that I work with are now procuring for student athletes. But it opened the door to this wildly permissive and very brief NCAA policy around what student athletes can do, which basically says if you're a student athlete or a prospective student athlete, so it includes kids who aren't in college yet. If you're in a state where there's a state law about this, you got to follow the law. If you're in another state, bylaw 12 about amateurism is just gone. And here are three things maybe you can't do. You can't get paid to play. You have to do work for the money, which clearly was intended to keep boosters from just funneling money to students, but to me evinces the fundamental misunderstanding of intellectual property rights, because the name, image, and likeness rights have value in and of themselves. And you can actually, as a parent of student athletes, I would have liked a law that said you can exploit those image rights and license them to third parties, but you can't actually do work. You put them on physical products, you do things, but you shouldn't be out there making personal appearances. You should be either in the classroom or on the ball field. It's the doors really up. I mean, I think we were literally sitting, in our offices in June, early June or May, going, what's going to happen on July 1st? Like, nobody really knew. We were waiting to see what the NCAA comes around with. The Alston decision comes out, and that last week of June was just bonkers. And there's leaking what the NCAA policy is going to be, and what they ultimately issued was, so wildly broad that it actually put the states that were trying to get out ahead of this issue so that they could recruit student athletes and come here and you'll be able to exploit your name, image, and likeness. Those states, student athletes in those states actually have to follow more restrictions in many cases than in the states that did absolutely nothing. Where are we now? It's a complete shit show, frankly, I can't think of an appropriate word to use in an institution like Notre Dame other than that. Sorry. I tried to think of something else, but 25 different laws in these states. They were written really quickly with a view toward just getting them in there. They're all maybe 2 to 4 pages long, but there's no template. They're all different. I mean, I could go through if you want to read. I mean, there are a few. The only similarities in all of them are you can make money from your name, image, and likeness, and you can use representatives to help you do that. But they run the gamut from there. I mean, Georgia's law says that schools can actually make student athletes give up to 75% of the revenues that they make from NIL to their teammates when they graduate. Which we'll get around to another point about team unity that I personally have on all of this in a few minutes. But some of them make it a crime for a high school student to engage in NIL activities. Some of them say high school students can engage in NIL activities. An agent came to me with a fact pattern that would be like a law school exam the other day. High school student in Arkansas is deciding between committing to UT and USC. Well, USC, if he's in California, high school kids can exploit NIL rights. Texas, they can't. Arkansas, the law's unclear, but they might lose high school eligibility. I mean, it's just wildly complicated. So, we spent a lot of time just reading and trying to interpret. I thought you were going to say I was an expert at NIL. I'm like, nobody's an expert at NIL because nobody, knows these laws. We're literally just reading them and trying to figure out how they apply and, trying, in my case, my darndest to keep our agents who are looking to sign and represent these student athletes from doing something wrong that's going to cost one of these kids their scholarships, because that's the worst possible scenario. It's one thing if we just do something wrong that impacts us as a company, but we don't want to be the guys that cause these kids to lose a scholarship. So, but you did one of the things you mentioned, Roger, at the beginning was that this really is a paradigm shift, and that's one of those things I step back from every now and then when I'm getting exasperated because we want to sign a kid at LSU and I have to read the Louisiana's NIL law, LSU's NIL policy, the NCAA NIL policy, and then the NIL policy says you have to comply with the state athlete agent law. So I got to read that one, and I got to read the school's athlete agent policy, and I've got to comply with the federal athlete agent law. Like, it's just, it's this crazy web of regulation. And sometimes you spend a lot of time at the end of the day thinking, God, this is such a, but then you step back and you realize this is an incredibly monumental moment in the sports marketing business, in the, in the collegiate sports world. So it's, it is pretty cool to be a part of, but, we're all really finding our way in the dark right now. I think in terms of, in my mind, sort of where we were, where we are now, and where we're going, where we were was before all of this change, as already been said, you had institutions making billions and billions of dollars with nothing going to the student athletes. But then you kind of I had a funny conversation with an Uber driver on the way over here. I told him I was coming to speak at this conference, and he said he played football at Syracuse. Guy's probably my age. I forget. There's some player that played the Broncos he played with. He's like, yeah, he used to drive around in a pink Lincoln Continental. Nobody knew how he got that car. So schools were making billions. Boosters were, kind of in the background channeling stuff to kids. Like, some kids were getting paid, but then kids, I mentioned this to you, Roger, the most egregious other end of that spectrum was college basketball players who put trick shot videos on YouTube lose their scholarship because they're monetizing their sport by getting the AdSense money from YouTube. So, it was institutions, tons of money, some kids kind of getting this back channel money, and some kids getting screwed for not even really making money. And where we are now, I feel like it's sort of, the institutions are still making a lot of money, although there is one thing that I've noticed, there is some concern. I mean, the media rights are going to be there, and Jeanifer, I completely agree with you that the kids that are in those, in those presentations should be compensated for that. But the sponsorship money, there are a lot of schools that are very concerned that the all states of the world, or whatever their big official sponsors are going to start spending less on the schools because they're going to start giving that money directly to the student athletes, which from where I sit as a representative of the athletes is fantastic. And it's, so however you get it there, some of this money is actually moving from flowing directly into the school to flowing to the student athletes, which in my view is a good thing. And then as it relates to, the pink Lincolns, I mean, for that, I say what was once in the dark is now in the light. And I haven't decided yet if that's a good thing or a bad thing. You know, boosters are finding ways to get money in kids' pockets. You know, I don't know how. Well, I have a funny example of one. So I don't know if folks heard about the brand that provided compensation, NIL compensation to everyone on the BYU football team, and then actually paid for the tuition for the walk-ons. So tuition, I looked up at BYU, is interesting. Well, interestingly, it's $12,240 if you're not a member of the Church of Latter-day Saints, and half of that if you are. So if there's a fair market value requirement, which there is under the applicable rules here, that you have to be licensing your image rights at fair market value, apparently at BYU, non-Mormons have double the market value for their NIL rights that Mormons have. Interesting. And query whether, you know, at the minimum wage in Utah is $7.25. So if we took that $12,240 and divided it by the minimum wage, that's about 1,600 hours of work. So I'm not really convinced that that's a fair market value grant of name, image, and likeness rights, but seems to be okay. And that really brings me to the one of the concerns I have about where we are now is the schools. Even though the kids are getting money, the schools are getting the benefit of a lot of this because the boosters are able to give the money directly to the kids. You know, you've got guys like Saban saying, my quarterback, you know, at Alabama, our quarterback's going to make $1 million in NIL deals. And if that's not recruiting, I don't know what is. But the schools are actually the ones that are policing this. The NCAA punted all the oversight authority to the schools. So, you know, you've got an Alabama compliance officer blessing a deal between an Alabama booster and an Alabama athlete that the NCAA will ultimately have a say in whether that was compliant or not. So the whole thing is really kind of a mess. I think it's a positive mess. I think it will get worse before it gets better. I think kids will get, you know, taken advantage of by agents, get taken advantage of by brands. I'm sure somebody will do a study comparing the pre-NIL grades of student athletes to post-NIL grades of student athletes. You know, I think there's just going to be a lot of continued confusion in the marketplace. I think kids are going to lose scholarships because they're going to go too far. The rules on improper payments by both agents and inducements by both agents and schools are still there. So it isn't really a free for all, even though it feels like this. I think, you know, from my perspective, some of the things that Jeanifer's pushing towards, having a more unified system of compensation for these players, I think will be better in the long run. It'll be more fair. I think it'll lead to a lot more team unity. I think having, you know, one player on the team that's making tons of money on NIL and, you know, a lot of guys working harder than them who aren't, is going to create a bit of fraction. But it's, I think, just getting to a point where, you know, in light of the NLRB, I guess it wasn't a decision, it was an opinion recently that, you know, the kids should really be employees, and I think there should be a union, and they should be able to do group licensing through the union, just like the NFL and the NBA Players Associations do, but also retain the rights to do their own personal NIL deals as well.
Great, thank you very much. So let me ask a question for the group. Picking up on the last point that Lori mentioned, I'm curious about NCAA compliance regulation and how they're going to enforce compliance in the changing world of antitrust scrutiny. I mean, it's commonly said in the world of antitrust that competitors in the market act differently when they know that the policeman is watching everything that they do. And now, all of a sudden, the NCAA knows that they no longer have immunity. and that their behavior will be scrutinized under a rule of reason, balancing pro-competitive and anti-competitive conduct. You wonder what NCAA is going to do with respect to monitoring compliance in a world where any of their decisions could trigger additional antitrust scrutiny. So I open that up for anyone on the panel that might want to answer that. Jeanifer, do you want to start? I'm sure you thought about that one.
Yeah, I can jump in. So, I mean, I think, and, you know, to Lori's point, I think the Alston decision, while it blesses a kind of narrow set of benefits, narrower than we asked for in the beginning, and it's an affirmance of the lower court decision and doesn't go further, the real strength of it is that the NCAA is subject to antitrust scrutiny. I mean, the sorts of arguments that they made to say that they really shouldn't have to face lawsuits like this were roundly rejected. And everyone said, you know, everything you do is subject to an antitrust lawsuit, essentially. For compliance, it's a little bit different because it's not going to be an agreement among the schools. The NCAA has had, you know, medium success at compliance. I mean, there's a lot of activity from boosters that has gone on, and I think, you know, what we've seen from them is not a great job at making sure that the rules are adequately enforced, and that's especially the case on things like, you know, academic issues where they've almost disclaimed that they have any responsibility to make sure that the athletes are really even getting educations, which is something they said after, you know, the UNC scandal. So I think that it's less likely that that sort of behavior from them is going to be challenged by antitrust laws. But I think that what you'll see is that the schools and the athletes and conferences have a lot more power to push back in the new reality. The NCAA is going to have, I think, a lot less power to just say, you know, you're ineligible or you vacate wins. And that even if they do, the impact of that is not going to mean what it did before. So I think there's a much more limited role for them in terms of compliance. And I mean, I share Lori's thoughts that, you know, there will be kind of more disruption before we reach some sort of equilibrium, that there is a lot of things that are going to need to be figured out. And, you know, we won't see something that's totally uniform from the beginning, but I see the NCAA having certainly a diminished role in doing compliance, because I think, you know, they're not going to be as interested in taking that on.
Roger?
Anybody else? Yeah,
Roger?
yes.
Sonny? Just going back on what Jeanifer said and Lori mentioned, they cannot be the judge and jury to these athletes. They've been the judge and jury forever. That's the sin. And the Miami case was sinful. The academic thing that Jeanifer did in North Carolina was egregious. The patheticness of the total operation, and I don't mean to demean all of the investigators who I've met through the years. I don't mean the people in the field, but you know what? The people in the field really were the ones that brought the information to the individuals who made the final decision. I'll leave you with this, and all of you should never forget, when they actually had the kid incriminated out in California while the mother or the boyfriend and girlfriend were on an airplane, and they said, well, we know he's guilty. Well, they were the only two that knew he was guilty, were those two on the plane who worked for the subway before anybody. It's impossible for them to be the judge and jury of the athletes. And to go back to what Lori said, and Jeanifer, both in your thing, and I'll get off, is the sin doesn't stop 5 years back on the Alston case. The sin starts the thousands of kids who played sports that never had an opportunity because they didn't know what the hell name, image, and likeness in the Alston case meant. They were deprived of their rights to be able to do things. And that goes to the injured ones with the concussions and the broken legs, and the ones that, the hardest thing you can witness as a fan is when a kid goes off the field and he puts thumbs up as he's laid there crippled probably for life. So, but going back, they can't be the judge and jury. You know, they have too much power already. That's the first thing I'd eliminate.
Makan, do you want anything? Or do you want to ask a question of one of the other panelists?
Just a quick fact, issue, no, thank you. Nothing to add on that. I think, from a design standpoint, it's going to be interesting to see what happens. What does the NCAA put in new rules, or are they going to say, oh, we're concerned because whatever rules we put in here, again, the decision says that there's a lot of leeway. I think the exact words of Justice Gorsuch to them. But I think from a design, we've seen this in securities regulations, for example, where you have a self-regulatory organization like the National Association of Securities Dealers or the municipal securities rulemaking boards. They would set the rules, but adjudication of those rules is to a separate body. And I think generally that's not a bad idea. I think that's a good idea, but that's really for NCAA to decide what it does going forward. I think it would give a lot more credibility to their decisions and give a lot of comfort to the subjects of their rules. The one question I had just for Jeanifer is that when did the Alston case start? I know it ended this summer, but when did you guys actually file the case, and how long did that take to litigate that to where we are today?
We filed the case in 2014, so it has been quite a while.
7 years.
Yes, and it is really interesting to see how quickly the change has happened. When we first filed this case, and I would speak about it, I had a much more wide variety of responses from people. I mean, I have friends who were in finance that are free market crazies and would say, that they didn't believe the athletes should be paid. And, there was a lot more kind of negativity around it. And I think what we've seen is a really rapid change to where people have come around to seeing the unfairness in this. And I think that's in part due to, how much broader name, image, and likeness compensation and use has become with social media. It's really everywhere. And it's hard to see why student athletes wouldn't get to do things that, an Instagram influencer does. But, that's been 6 years, which is a long time, and it's a long litigation. But as Sonny was saying, I mean, the injustices here have been going on for much, much longer than that. And there's a lot that can't be remedied. But in the short period of time, I think really public opinion has come around to thinking that there was unfairness here that just couldn't be justified.
I think that, ultimately, whatever the solution becomes, and I was trying to look for the exact quote from Justice White. Justice White, obviously, not only a Rhodes Scholar, but a first round draft pick and an incredible collegiate athlete himself on the Supreme Court. But he would, upon his retirement, he left us with some words that said that, he was talking about rulings from the courts and from the Supreme Court, that the rulings should be made in a, quote, clear, crisp manner, leaves as little room as possible for disagreement about their meaning, end of quote. Now, that's a challenge. That's difficult in the world of antitrust law. Justice Gorsuch, I think, cautioned against a judge or anybody in the courts becoming central planners of any organization. What does that mean? That means it's going to be difficult. You're not going to have, a judge like we had in the AT&T case in the 80s through 1996, Judge Harold Green, who ultimately became the telephone regulator. That's really not an appropriate role for judges or really for antitrust law. But that's kind of what we're facing now. I think this judge in California is going to now become, in effect, the super commissioner of collegiate sports because they have a lot of discretion to determine what practices are legal and what are illegal. Of course, constantly being tested, probably by folks like Jeanifer and her colleagues and others, depending on what those rules are. But that's a real challenge. And I think that it is important for some set of rules to come into play. Now, whether or not that's a compromise, we saw this in other sports, in baseball, in football, in professional football, after some antitrust challenges. Those were done through collective bargaining agreements, but somehow I think there needs to be an answer here that needs to provide some clarity and be clear and crisp, so that folks like Lori know what to do in this. The general counsel of Notre Dame or UCLA knows how to advise the school in what the rules should be. I think everybody agrees, there needs to be some rules. You can't just have the kid wake up, with $100 bills under their pillow, as Justice Gorsuch famously said about the 1946, I think, University of Pittsburgh player who made less money going pro than he made being in college because nobody was leaving him money under his pillow. But they need to be consistent with the antitrust laws. They need to provide for protection and the ability to, I think, be properly compensated. So what is that? I don't know. I don't have the answer, but I do believe there needs to be some set of rules to allow for competition to occur on the playing field without the fear of constant litigation. But that also means there needs to be some give and take on both sides of this in order to come up with a set of rules that provide some certainty.
So maybe some questions from the audience. Ed, can I start with Ed? Do you have a question, Ed? You're our Matteo. Go ahead. President of the Sports Law Society, Matteo.
Ms. Odierno mentioned the BYU deal with Bill Grant. Utah has no NIL statute on the books. You or Ms. Parsigian you talked about market value. The most money are the non-scholarship athletes, people that probably got the walk-on. Much. Could you mention how that would affect fair market value of their NIL deals, and also how this could also affect Title IX violations, because the entire walk-on football team received basically scholarship tuitions, and the female university received nothing, and so creating imbalances in opportunities for males and females.
Yeah, that's a great question, and also so maybe Lori and Jeanifer, because this is not money coming from the college, it's coming from third parties, but it still might trigger a Title IX violation, right? If the money's flowing to male athletes instead of female athletes. Do you want to start?
Yeah, I'll leave the Title IX piece to Jeanifer, that sounds better for Ally. I think, the fair market value requirement is one of the few things that's in the NCAA policy. So Utah is one of those states where there isn't an NIL law, so you just have to follow the very limited requirements of the NCAA policy. I don't know how that arrangement passes the fair market value test. I just don't, and I would not be surprised if someone at some point challenges it or other arrangements like it, because I don't know what the consideration was that they provided in exchange for that compensation. But if it's a few Instagram stories and a personal appearance, I don't know how you can say that, and maybe they were all members of the church, so maybe they all did get the same, but in a scenario where you could potentially have the same people getting double the compensation based on how the tuition is structured there, I don't know how you say that's fair market value unless that person who got double the compensation had double rights.
Jeanifer, do you want to add anything?
I do. So I didn't hear much of the question, so I will kind of guess at what has been asked. But
So the Utah donor is giving money to the BYU team, and it paid the scholarships of the walk-ons for the football team. All of the money is flowing to male athletes, and none of it's flowing to female athletes.
I see.
And your Title IX question.
So I'll first just respond to Lori and comment on fair market value. I think fair market value in this area, just there is a lot of room for what that means, right? There's not much to compare it to. Your name, image, and likeness is unique. It's to you, and it's what does a sponsor think it's worth, and it may think providing compensation to a walk-on has specific worth to them as a sponsor. So I think that there's certainly a lot of gray there. I think it will be hard for the NCAA to say that something like that is not compliance. But you know, we don't know what they will do, and they've done, in my opinion, crazier things before. In terms of Title IX, you know, Title IX applies to the school. So I think it's hard to imagine how it would be enforced here in a way that said, you know, that's unfair. You know, we are in Litigating House very interested in how this is playing out. And it's a fascinating, you know, natural experiment, as economists say, to see what happens now that this rule has changed. It has not been the case that we've seen this money flow only to male athletes overall. And I think one of the things that, you know, we work with Dan Rasher, who's a sports economist, and we've worked with him in on a lot of cases. And one of the things that has made him excited is to see how much this really has opened opportunities for female athletes who may have, you know, really large Instagram followings and may, you know, have names for themselves in ways that aren't the traditional sports ways, like just being on, you know, an ESPN, but have access to a big market, and, you know, then, you know, women's clothes and women's, you know, various things that you want to appeal just to women. It actually opens a lot of doors to them. So I think we.
Oh. The young men are following them too.
Yeah, but Laura,
Yes.
what was the name of the institute in Louisiana? The what's the LSU gymnast?
We signed the first NIL client we signed was Olivia Dunn. She has a couple followers on Instagram. She is, you mentioned at one point that some of these student athletes are like influencers. They are influencers. Olivia Dunn, social media influencer.
She's a gymnast at LSU.
And she happens to be a gymnast at LSU. So she was precluded from being a social media influencer, you know, in any way that showed her functioning as a gymnast, or she would risk losing her scholarship. Now she's able to do that. And is, you know, there are plenty of brands that would love to associate themselves with, you know, a young, attractive woman with 2 million Instagram followers.
Yeah.
Roger, can I ask the last question? This will be.
Yeah, second to last. Patty O'Hare will be the last question. So go ahead, Sonny.
I'm sorry.
Go ahead, Sonny.
Lori, what do you think of the 1,000-pound elephant in the room? The Division Street thing Phil Knight started. I like it. I'm not always in agreement with Phil Knight, that's for damn sure. But I'll tell you one thing, that's an interesting thing, right? We have somebody really, really important, and he's interfering with basically your business and other people's business. But I think it'd be good because I think they're very qualified. Very interesting. No one's talking about it. To me, it's huge.
Sonny, I was interested in your thoughts on the overtime league.
Well,
you know, where we're actually paying.
we don't have, I mean, I'd love to answer it. Roger, I don't want to infringe. I know we're at the clock, but the overtime, or is that the night thing?
Yeah.
Overtime, the professional league that started, or yeah. Well, it's overdue, but I think what happened to them, and it's going to hurt them, is name, image, and likeness in major court. John Calipari came out with the best statement of all the coaches. Come to Kentucky, we have 10 million people that want to do 10 million things with you. And Johnny said it out in front of the world. Eventually, it'll be run by the alumni, as you so aptly put. There's no question about what will happen. It'll just be up front, that's all. I mean, I can see, you know, FedEx doing something in Memphis. I can see, you know, when Nike is doing something. But that's what it'll be. And not that that's bad, because it was probably done in other ways in other years, Lori, and to our audience out there. But I thought what Phil basically did, and obviously he's got good people, he got LeBron's people behind it. It's a very interesting curmudgeon, isn't it? Because basically that wasn't what everyone thought it would be. But it's not bad. It's not bad. It's good for the athlete.
Yep.
So, last question, Dean Patty O'Hare.
I'd be interested in the panelists' opinion about whether the NCAA survives. They had a decade between Odierno and Alston to have done something proactive, and instead they go into the Supreme Homer Ale, and they put all their eggs in the amateurism argument against all of the data with respect to the money that's being given. So there's no question, as you suggested, that regulation is necessary. Is the NCAA the entity that's going to solve the problem?
Anybody?
Roger, would you mind repeating the question?
Well,
The NCAA
can the NCAA survive in light of these developments? They put all of their eggs in immunity and amateurism, and they lost big on their core fundamental argument
10 years.
for the past 10 years. So the question is,
Sure.
what's the future for the NCAA?
So, I mean, let me just comment quickly on that, and I'll just again go back to the opinion. The NCAA, I mean, they can. It's really, I think, up to them. They lobbed a number of arguments, and the court unanimously said, no, this doesn't apply. And this is some of these concerns are overbroad. For example, one of the concerns they raised is that, oh, we won't be able to stop, somebody from giving a student athlete an internship post-graduation. Justice Gorsuch went on to write, and he says, no, the district court enjoined only restrictions on education-related compensation, quote, that may be made available from conferences or schools. And it goes on and says you can't, we're not limiting that. So there are rules that they can do, and they could test again, but all of the power is now going to be in the district court judge, if that's the approach they take. Now, the other approach is for them to go, I think, sit down with the players' representatives, Ramogi, Huma of the Collegiate Players Association and others, and see if you can have a negotiated process where, you recognize health and safety and some restrictions, and take that negotiated compromise to Congress and mix that up with an antitrust immunity in exchange, and maybe some labor restraints. And that is, I think, that's the future of this, for them to do that. But that requires both sides to come together rather than litigate this to the nth degree.
Great. I think we are out of time. Thank all of the panelists. Can we give them a round of applause, please? To be continued. Thank you very much.